My name is Marjorie Rendell. I'm a judge on the United States Court of Appeals for the Third Circuit. And today we're going to talk about a case decided by the Third Circuit. The case is called Saxe versus State College Area School District. It was a case that we heard in the year 2000. And the panel, we sit in panels of three. The panel consisted of myself, Judge Samuel Alito, who is now a justice on the Supreme Court, and a visiting judge, Judge Dewey. So we were presented with a situation where students had brought a lawsuit against the school district challenging a harassment policy, actually an anti-harassment policy that the school district had adopted. Now, the students had not been found to have violated the policy. In fact, the policy had just gone into effect and they brought suit. So why could they bring suit when they really weren't targeted by this policy? Well, the case involves the First Amendment, freedom of speech. And when you have freedom of speech, people can come into court and contend that the policy in this instance violates their freedom of speech, and it would have a chilling effect, meaning it would prevent speech by people. So we have an interesting situation involving the First Amendment where someone doesn't have to have been found guilty of something or liable for something, but they can come into court and contend that the policy here is unconstitutional. How? They contend that it is overbroad and vague. Now, what does that mean? It means that they say the policy actually says people cannot engage in certain speech that they have a constitutional right to engage in. So the policy takes in more in the way of speech than government really can prohibit. So we have an interesting situation involving these students who have certain religious beliefs. And they are afraid that when they talk about these religious beliefs, which really it's against homosexuality, they're afraid that if they speak, they're going to be caught up with this policy. They're going to be probably kicked out of school or suspended because they violated. So they want the court to decide whether the policy is valid or not. And here the district court, the trial court, determined that the policy only punished or prohibited speech that was already prohibited by federal law, so that the fact that the policy just merely parroted what was violative of federal law meant that the policy was okay. Well, it comes up to the Court of Appeals, and Justice Alito and Judge Dewey and I look at it and say, you know what? We are not so sure. The policy, let me tell you what the policy says, that harassment means verbal or physical conduct based on one's actual or perceived race, religion, color, national origin, gender, sexual orientation, disability, or other personal characteristics, and which has the purpose or effect of substantially interfering with a student's educational performance or creating an intimidating, hostile, or offensive environment. So that's a lot. So we had to decide, does federal law already prohibit these types of speech? Or is this something we need to look a little bit closer and see, is this too broad? So we attack the issue from the vantage point of the district court, which is what we usually do on appeal. We have to decide, are they right or wrong? Well, we decided in the first instance that the district court was wrong, that this merely covers what's already prohibited by federal law. And we noted that, well, we have workplace harassment policies, we have certain policies under Title IX. Really, there is no Supreme Court opinion that addresses harassment in a general way, the way this policy does. So we had to look a little bit more closely at the language of the policy and figure out what it does, whether it's too broad, whether it covers some things that are actually constitutionally protected. So where did we turn in order to examine that? Well, we looked at the school speech cases, because that's what this is. This is speech in the context of a school. And we looked at what the cases had decided. And of course, if you looked at any of the cases in terms of school speech, you know of the case of Tinker versus Des Moines, where students wore armbands to protest the Vietnam War, and the school suspended them, fearing that there could be some problems, some disruption, the Supreme Court took the case and said, no, there has to be a real imminent danger of disruption, substantial disruption. And here in Tinker, there was not. The school districts just imagined, well, maybe there could be problems. But the Supreme Court said, unless there is substantial disruption or interference with the rights of other students, you cannot prohibit speech. And of course, in that case, it involved political speech, views about a current event. And that's a pretty high priority or high value speech. And we look at speech differently. There was another case, school speech case, called Fraser, where a student in an auditorium, in an assembly, gave a speech promoting a candidate for student government, but used lewd, vulgar references. And the Supreme Court said, those kinds of references are not valued speech. And there was a captive audience there, and they prohibited that type of speech. So every time we have a situation involving speech, we look at the type of speech, we look at the context, and we look at the breadth of what is being prohibited. So here we have a situation involving harassment speech, which we think, well, that's not nice. That's not good. We shouldn't value it. But in Tinker, the court said, you really can't say that speech is prohibited because it would offend someone or cause someone discomfort. That's not the test. So we have to drill down on harassment speech and figure out whether it is prohibited or whether it is allowed. And a lot of countries have laws prohibiting harassment speech. And they're somewhat broad. But in the United States, in our court system, we really have to drill down and look at exactly what is being prohibited and see whether it should be prohibited or not. So let's look at this. And this is what we did actually in the case. We looked at the Tinker standard because that's really a helpful one. It talks about substantial disruption or interference with the rights of others. So in the Saxe case, we looked at the language, and it has all of the introductory languages, verbal or physical conduct, et cetera, which has the purpose or effect of substantially interfering. Purpose or effect. Well, effect is one thing. It has the effect of substantially interfering with another student. Then we can say under Tinker's standard, that's really something that we can prohibit if it has that impact. We look at the impact, disruption or interference, if it has that impact. But if it has the purpose, so I'm speaking out, I'm saying bad things, and I have the purpose of interfering with another student's rights, but it doesn't have that effect. Well, that is overbroad. It has the purpose or effect. So someone could be suspended for speaking in a way that has the purpose of interfering with another student, but actually doesn't do that. So we said that is overbroad, and you can't have a policy that prohibits and punishes for that kind of speech. So let's go on. It says purpose or effect of substantially interfering. And here we're talking about this. We're actually giving advice to school districts. If you want to craft a policy, talk about the effect. Don't talk about the purpose. So we went further in the definition with the student's interfering, substantially interfering with a student's educational performance or creating an intimidating, hostile, or offensive environment. Well, a lot of things that are said, let's look at Tinker. It probably had the possibility of creating an intimidating, hostile, or offensive environment. But is that enough? A lot of things that people say, people take issue with. I express my views about a political party or a candidate, and it creates an intimidating or hostile environment for someone because they disagree and they want to complain about it, so it's offensive. But Tinker said, just because someone is made uncomfortable or is offended doesn't mean that it is prohibited. So we have two ways in which this policy is problematic. It is overbroad. It includes within its sweep conduct that is actually constitutionally protected. A lot of people would say, well, flag burning or doing something like that that desecrates the flag, that should be prohibited. But that can be an expression of people's viewpoint. Now, other people may take offense, but it is valued in our country that we have free speech, that even though if it's offensive, if it doesn't substantially disrupt the school or interfere with another student's rights. Now, of course, there will be harassment that does do that, that has that effect of disrupting, and that has that effect of interfering. You look at bullying, that is a type of harassment. So these things can be prohibited in the schools, but the school district has to be careful that it's not doing something that is not substantially disruptive or interfering with the student's rights. We have different situations where types of harassment are prohibited across the board. And you say, well, in what situations? Well, inciting someone to riot or imminent lawlessness, those types of speech are prohibited. True threats are prohibited by law. Fighting words that provoke violent activity. And we do have hate crimes. Hate speech can be merely offensive, hateful, but offensive. But when there are crimes that are motivated by hate, we have hate crimes, and we can indict people for hate crimes. So there are situations where certain types of speech are prohibited across the board. And then, of course, we do have that school context that I spoke about. And it's interesting that we go back to Tinker. Tinker is probably 70 years old as a case, but it is case precedent. And that's the key part of this case. It's the fact that once we clear away what the district court did, we have to decide what's the guide for how we look at this harassment policy. And it gets back to Tinker, the substantial disruption, and that's where we draw the line. So much of the First Amendment is drawing that line. You can yell fire outside on the street. You can't do it in a crowded movie theater. We draw that line. You can say something is bad, but if what you're doing is harassing them and interfering with their ability to do their studies or to attend school, then we draw that line. So much of what we do in the First Amendment is drawing that line. And we look at precedent. And here we're fortunate that we do have the Tinker case as precedent. A couple of years ago in my court, we had a case involving a cheerleader who had put some objectionable comments on her chat box, complaining about the fact that she had been let go from the sports team, and she was, let's say, upset. So the tape went viral, and we had to decide whether we stick with the Tinker standard when the conduct involved outside school. And we decided in our court that once it's outside school, we would say the school really doesn't have a basis for complaining or prohibiting or suspending the student. The student had been suspended and, of course, complained. So we decided that if it's outside school and really doesn't impact the school, then the school can't regulate it. Well, the case went to the Supreme Court, and the Supreme Court said, no, you know what? We're still going to look at that Tinker standard. We're still going to look at whether wherever it occurred, it involves substantial disruption or the interference with the rights of other students. So they went back to that bedrock principle of Tinker. I think we had been trying to give a little bit of certainty to these school districts. They have to decide, very quickly, what are we going to do in the face of what has occurred? And they, of course, consult their counsel, and they say, well, is it Tinker? Is it something else? It's outside school. I think the Supreme Court, though, decided that in light of the fact that the school walls these days really aren't the end of what happens in school. So much is on social media. So much of what's going on pervades life outside of the four walls of the school. So the Supreme Court said, I don't think this inside-outside school district or school building makes a lot of sense. Let's go back to our precedent. Let's go to Tinker and give the school district the right to figure out whether there's going to be imminent disruption or whether the students' rights are being interfered with in a substantial way. So once again, we adhere to precedent in our court. And the Supreme Court had the opportunity to change the precedent. But they said, no, Tinker is good. Tinker really works in the school system. It's something that the school districts can analyze, and we're going to adhere to that. So it's interesting that these cases come up every other day in the courts, with the courts having to really look at what's going on. What is going on in the school? Is the school environment disrupted? We can't have an educational system in an academic situation where we're disrupting the school. And we can't have a situation where kids can't enjoy their school situation, where their rights are being interfered with. So we adhered to precedent in the Saxe case. It's interesting that Justice Alito and I agreed very often on First Amendment cases. I must say, on other cases, we didn't agree as much, but First Amendment cases, we pretty much had the same viewpoints. So there you have it. And now you've heard the views of Justice Alito and Judge Rendell on a topic that is very current. And we think that we gave guidance to school districts as to how they craft their policy. They can't do it with something having a purpose or creating an offensive environment. They have to look at the effect on the schools. So I hope you've enjoyed this little summary of the Saxe case, and look forward to speaking with you again.